Welcome to our channel Future Stenographers. Ready for the dictation? 10 seconds, 5 seconds. Ready, start. Challenge in this appeal is to the order passed by a division bench of the Punjab and Haryana High Court allowing the writ petition filed by the respondent number 7 Daljit Singh purportedly in public interest as a public interest litigation. Stop. Respondents 1 to 6 were official respondents in the writ petition. Stop. Grievance in the writ petition was that the appellant had got appointment as audit inspector cooperative societies Firozpur on the basis of scheduled caste certificate, though she was not member of any scheduled caste. Stop. It was averred that the appellant was married to Sri Jagminder Singh, member of the scheduled caste, and it was on that basis aforesaid certificate had been obtained. Stop. It was stated that in spite of several complaints made to the authorities, no effective action was taken. Stop. The official respondents filed a reply to the effect that proceedings to cancel the scheduled caste certificate were under progress and therefore the writ petition was premature. Stop. The appellant filed a written statement stating that on account of her marriage with Jagminder Singh, she was to be considered as a member of the scheduled caste. Stop. It was pointed out that the writ petitioner was not qualified and only because of personal vendetta he had filed the writ petition styled as a PIL. Stop. The High Court, by the impugned judgment, issued a writ in the nature of qua warranto, setting aside the appointment of the appellant. Stop. In support of the appeal, learned counsel for the appellant submitted that in service matters, PIL is not maintainable. Stop. The writ petition was filed because of personal animosity and can by no stretch of imagination be considered to be a public interest litigation. Stop. Learned counsel for the respondent number 7, on the other hand, submitted that since the appellant was not entitled to a certificate to the effect that she belonged to any scheduled caste, the authorities were bound to take action on his grievances. Stop. Next para. The scope of entertaining a petition styled as public interest litigation, locus standi of the petitioner, particularly in matters involving service of an employee, has been examined by this court in various cases. Stop. The court has to be satisfied about bracket A, the credentials of the applicant, bracket B, the prima facie correctness or nature of information given by him, bracket C, the information being not vague and indefinite. Stop. The information should show gravity and seriousness involved. Stop. Court has to strike balance between two conflicting interests. Bracket 1. Nobody should be allowed to indulge in wild and reckless allegations besmirching the character of others, and bracket 2. Avoidance of public mischief and to avoid mischiefs, petitions seeking to assail for oblique motives justifiable executive actions. Stop. In such case, however, the court cannot afford to be liberal. Stop. It has to be extremely careful to see that under the guise of redressing a public grievance, it does not encroach upon the sphere reserved by the Constitution to the executive and the legislature. Stop. The court has to act ruthlessly while dealing with impostors and busy bodies as public spirited holy men. Stop. They masquerade as crusaders of justice. Stop. Though they have no interest of the public or even of their own to protect. Stop. Courts must do justice by promotion of good faith and prevent law from crafty invasions. Stop. Courts must maintain the social balance by interfering where necessary for the sake of justice and refuse to interfere where it is against the social interest and public good. Full stop.